Hi, good morning. This is a great turnout. Thank you for coming. My name's Ruth Marcus, and I'm an editorial writer and columnist at the Washington Post. And occasionally I write about and wrestle with some of the issues that we're going to talk about today. I just wanted to very briefly set the stage for the discussion that we're going to have, and then turn it over to the panelists to talk at more length about the issues involved. It's really striking if you think about even the title of this panel, how quickly the debate over same-sex marriage and civil unions has changed certainly in the last 10 years, probably in the last 5 years. And I think we very much moved from whether to figure out a new set of legal rules to handle same-sex couples. Handle's not a great verb, so I apologize for that. To what is the best way to do it. And to me, actually, one of the most striking developments is the fact that next month we're going to have all of the Democratic candidates going to speak to the Human Rights Campaign to discuss this issue. And you have, I was really struck by John Edwards sort of apologizing for his opposition to gay marriage and pointing out that his wife and his daughter have a different point of view. Just very briefly to bring us up to date on where things stand in the last few years. One of the things is that right now we are on the verge of something that could really change the legal landscape. We're waiting for high courts in, I think, 3 states, California, Connecticut, and Maryland, and we'll certainly hear about one of them, to decide on the whether and to what extent there's a constitutional right to gay marriage. Meanwhile, the states have been extraordinarily active. In New Hampshire, the governor signed a law in May calling for same-sex unions. New Jersey began issuing civil union licenses in February to same-sex couples, joining Vermont and Connecticut. Washington and Oregon have joined California, Hawaii, and Maine in a sort of more limited right. And something we'll also hear about in New York, Governor Spitzer proposed a bill to permit same-sex couples there to wed. Meanwhile, on the international front, things have been also changing dramatically and quickly. The Netherlands legalized gay marriage, followed by Belgium and a couple Canadian provinces, Spain, and South Africa. So we're really very much in a different world than we were in on this topic, say, 10 years ago. And it'll be interesting to hear about what the best way, how this new world is going to develop, and what the best way our panelists think it is for it to develop or not. So right now I'm going to just start going down this way, and I'll first introduce Carrie Evans, who is the Director of Policy at Equality Maryland.
Good morning. Just one correction. As a Canadian, I would be remiss.
I'm sorry. As I was saying that, it is the country. It started with provinces. Yes,
so
thank you very much.
Of all my friends,
as I was saying that, I
was
thinking, I'm cribbing from this, and it's wrong.
So we have an entire country up there. So, as Ruth said, I am the Director of Policy at Equality Maryland. We are the statewide LGBT organization working on a lot of issues, but right now almost focused exclusively on the marriage issue. As most of you know, we have a court case pending at our high court, the Court of Appeals in Maryland. We won at the trial court level in December 2005. And the Court of Special Appeals, the intermediate appellate level, did not hear the case. It went straight to the Court of Appeals, which heard oral arguments this past December. And every morning, weekday morning, there's a potential decision going to be handed down. We have no indication of what that decision will be, when it will be. There is no internal or external deadlines on the court. So we wait, and while we wait, we prepare for all the possible scenarios that the court could give us and make sure that our legislature is ready and that the people of Maryland are ready and that we keep the state conducive to marriage for same-sex couples. So as you all know, there's probably three likely scenarios our court is going to give us. One is an outright win, which of course would be, very easy for us. Then we would move to fighting a constitutional amendment, which we have been able to defeat for 5 years now in the legislature, but certainly the dynamics change incredibly when marriage is not a hypothetical anymore, and so keeping back a constitutional amendment would become our top priority in Maryland, and making sure our squishy middle that are with us now stay with us. Certainly, if we have an outright loss, we move to introducing a marriage bill. We have sponsors already aligned for that, and we'll introduce it immediately when session begins. And we work to pass that. Currently, we do not have the votes to pass a marriage bill in the General Assembly. We have to wait for an intervening election cycle, which doesn't happen for us in Maryland until 2010. So we have a lot of time in this, outright loss scenario for other things to happen between the decision and when we would have a pro-marriage majority in our General Assembly. And then, of course, the punting scenario where we get, like the New Jersey High Court, it kicked back to the legislature, a ruling of it being unconstitutional to deny the protections of marriage, but leaving it up to our legislature to decide how to remedy that. And that is where a lot of our work is around, is actually our lobbying efforts probably are quadrupled since session has ended. We have 3 full-time lobbyists as well as 3 staff members who basically are spending the entire summer lobbying our friends in the legislature about why, if that scenario is presented to them, they should reject civil unions and pursue marriage. And as you can imagine, that has been sort of an uphill battle, because for so many years, our community and our organizations have, told legislators, civil unions are a good thing. And so, a lot of our friends are all of a sudden like, well, now you don't want us to support civil unions. We don't, get that. So when you're working within, the allied community and our own community, I mean, certainly Equality Maryland has members who are not understanding why civil unions are not what is the top priority of Equality Maryland. So that has been, we have special lobbying materials exclusively for our legislators who we have to move to reject civil unions. Thankfully, there has been a lot of good journalists who have written great articles. We have, a New York Times article, a Washington Post article, the Concord, Monitor has talked about Vermont's inadequacies of civil unions. So we now have a good body of, real researched problems with civil unions in the states that have them. So that has been very much a good, useful tool for all of us working on moving our legislators to marriage. And part of what's, sort of tying into all of this is Maryland has a referendum process. So if a civil unions bill is passed, assuming a decision comes out before our legislature goes back into session in January, it is likely that that bill will be petitioned to referendum, which then means during a presidential year we would also be fighting a referendum, and all of the money that would, most likely go to some candidates would be used to be keeping this, the law of the land in Maryland. So it's interesting as we do our public appearances in Maryland at workshops and with people. I mean, this is like the topic. Like, everyone wants to talk about why we are not pursuing civil unions and why it should be marriage. And so we've had the sort of the benefit of, for months, being able to perfect our arguments and, work with people to figure out what messaging is working. And we have found, sort of the ways that people can understand it are in the context of, we've been with in front of straight audiences who are legally married and asking them, if they would trade in their marriage for a civil union, and really to honestly think about that. Like, would they, say, okay, yes, I'll enter into a civil union and give up my marriage? And most will come to the conclusion that they will not. With Maryland being 30% African American, we've really had an opportunity to work on walking that fine line between not exploiting the civil rights movement of the 1950s and 60s, but also really being able to try and draw those connections with African Americans. And one that has, really worked as far as just distinguishing that, even if you want to, hold on to the erroneous belief that civil unions are somehow equal, and that's the premise you're starting from, that doesn't mean, that the philosophical underpinning is not separateness. And talking about one of the analogies we use is the distinction of water fountains, and that, African Americans had the same water coming out of those water fountains, and it still inherently philosophically was not okay that they had to use the separate water fountains, even though it was the same stainless steel and the same equipment, that it just philosophically and ethically was the wrong thing to do. And that really has begun to resonate with some people as well. So then the whole libertarian argument we've been dealt with too is, why don't we just abolish marriage as well? And I mean, it's a serious, I had a debate with a libertarian radio show host in Baltimore, and as soon as I, told him that if you put, if there is a serious proposal on the table, either in Maryland or in Congress, of a way to confer, the 1,138 federal rights and responsibilities and the 459 Maryland rights and responsibilities through some vehicle, or abolish those, rights and responsibilities coming to a couple, I said, I assure you that the GLBT community will seriously consider that. But until those things are on the table as serious proposals, this is what we have before us, is the institution of marriage, and that is how all of those protections are conferred. And so they sort of, okay, and I'm like, so work on a serious proposal and we'll be there with you. So that sort of in a nutshell is what is, happening in Maryland. We're all just going to talk very briefly and then open it up for questions and comments. And I just wanted to recognize that one of my state delegates is in the audience, Delegate Sandy Rosenberg, who has been one of our terrific friends in the Maryland legislature and is at the forefront of, this battle as we prepare for marriage in Maryland. So, hello, Sandy.
Thank you very much. Alfonso David was staff attorney at the Lambda Legal Defense and Education Fund, but since April 2007, he's been special advisor to the commissioner for the New York State Division of Human Rights. And he'll talk about his perspective on all of this.
Good morning. First, I would like to thank the American Constitution Society for hosting this convention for now 5 years, and also Equality and Liberty Issue Group and Sidley Austin for sponsoring this session. When I was first asked to do this session and I got to think about what the question was, we're being asked to consider what is equality and the difference between marriage and civil unions. And the answer to me is fairly clear. Equality is more than equal rights. Equality is more than equal obligations. Equality is more than equal privileges. Equality is dignity. And I think we often get sidetracked, with this distinction between civil unions and marriage, because I think is a false premise. Civil unions and marriage have the same obligations, rights, and privileges. And so the main distinction between those two, I think, is dignity. And marriage is a fundamental human right that should belong to us all. And unfortunately, it does not. And that distinction is primarily based on sexual orientation. Marriage is a civil institution that has existed for many years. And as many of you may know, it has gone through a number of different permutations to include African Americans initially to have the right to marry, to include women, or at least treat women as equal partners in marriage, to allow interracial couples to have the right to enter into marriage. It is also an institution, as Carrie mentioned, that provide significant rights on both the federal and state level. There are more than 1,000 federal rights that are associated with marriage, and hundreds of rights that are associated on the state level. Gays and lesbians in this country, with the exception of Massachusetts, are excluded from marriage, and they are instead assigned to a separate institution, an institution that was created specifically for them, and that is civil unions. And many people don't know that different sex couples cannot enter into civil unions. Civil unions are only available for same-sex couples. And that sort of begs the question, why are different sex couples precluded from civil unions, but they can enter into marriage, and same-sex couples are precluded from marriage, but can enter into civil unions, when both institutions provide the identical same rights? Civil unions would not exist if opponents, or I should say proponents of civil unions, believed that same-sex couples are equal. And I think that is the discussion that we should be having. Because if there was an identification that same-sex couples are the same as different sex couples, there would be no need to create civil unions. In New York, we are actively working to include same-sex couples into the existing institution of marriage. Governor Eliot Spitzer, my boss, became the very first governor in the nation, to introduce a marriage bill to equalize marriage rights, both for different sex couples and same-sex couples. And there's the legislative intent of the bill that I would like to read, because I think it's illustrative of what I think we're trying to accomplish in New York. And it says, marriage is a fundamental human right. Same-sex couples and their children should have the same access as others to the protections, responsibilities, rights, obligations, and benefits of civil marriage. Stable family relationships help build a stronger society. For the welfare of the community and in fairness to all New Yorkers, this act formally recognizes otherwise valid marriages without regard to whether the parties are of the same or different sex. It is the intent of the legislature that the marriages of same-sex and different-sex couples be treated equally in all respects under the law. And we hope that one day same-sex couples will realize that they will be treated equally under the law. Unfortunately, as some of you may know, same-sex couples are not treated equally underneath the law, not only with respect to marriage, but with respect to employment, housing, and public accommodations. We enforce at the New York State Division of Human Rights the Human Rights Law, which is a comprehensive statewide law that prohibits discrimination based on sexual orientation and gender identity, among other protected classes. And our intention and our goal is ultimately to eradicate discrimination, and that's a pretty lofty goal, but that's ultimately what we're trying to achieve. And at this point, same-sex couples are attempting to seek and obtain equality under law, and marriage is one of the most, if not the most fundamental tool to do that. And in closing, I will say that although I think most same-sex couples would admit that civil unions are a welcome advance in discourse in terms of advancing legal rights, privileges, and obligations, the reality is it doesn't equalize, it de-equalizes all of our dignity. Thank you.
Thank you. Shannon Price Minter is Legal Director for the National Center for Lesbian Rights. Shannon?
Yeah, well, thanks, Ruth, and thanks to ACS, too, for organizing this very important conference and including a panel on this topic, which is really shaped up to be one of the most pressing human rights issues of our time. The reality, as we know from the most recent federal census, is there are at least 600,000 same-sex couples who are living in this country. Many of them are raising children. These are, of course, real families with real children. And the question for all of us is, how should the law respond to that reality? That's a question that we all have a responsibility to answer. We know that excluding gay people from marriage will certainly hurt those families. It will not cause them to disappear. It's not going to change the fact that those children have lesbian and gay parents. ultimately this is a human issue. It is not a partisan issue. It's not conservative versus liberal. There are many conservatives who support marriage for same-sex couples. Many of the judges who have ruled in favor of same-sex couples in the marriage cases have been Republican appointees. The majority of them have been, in fact. If I could just speak personally for just a moment, my parents, who are arch-conservative Texas Republicans, have over time come to embrace full equality for lesbian gay couples, including marriage, and that's because the issue affects their children. It affects people that they love. And that's really the ultimate context of our discussion today, and I don't want us to forget that it's real people and real families that we're talking about with this issue. I want to just revisit a little bit the territory that Ruth covered, just kind of what's the legal snapshot. The only state where same-sex couples can marry is Massachusetts. Internationally, we got Belgium, Canada, the Netherlands, and a little bit more surprisingly, South Africa and Spain. In Massachusetts alone, there have been more than 12,000 same-sex couples have married just in the 2 years that marriage has been available there. And I'll just note as a footnote that Massachusetts continues to have the lowest divorce rate in the country. So predictions that letting same-sex couples marry would be destabilizing have proved completely untrue. And on June 14th of this year, the Massachusetts legislature voted to defeat a constitutional amendment that would have banned a marriage for same-sex couples, and they did so overwhelmingly. It was really quite an astonishing vote. The vote was 154 against, 46 in favor. Only 50 votes in favor would have been enough to have that amendment go on the ballot for a popular vote in 2008. And this is widely, and I think quite rightly, viewed as a really significant watershed moment. So no matter what else happens now in the rest of the country, same-sex couples are going to be able to continue to legally marry in Massachusetts. And what we saw there over time is the intensity and level of political opposition just dropping to the point where they were able to get a supermajority that's not available for very many issues at all in this country to not let that go forward. And then another watershed, November of last year, Arizona became the first and unfortunately still the only state to reject an initiative banning marriage for gay couples. It was defeated very handily. Now, we'll note that Colorado, Idaho, and Wisconsin that same year, last year, passed similar measures, and there's only a handful of states now that have avoided those measures, but I think we probably have hit the wall on that issue politically. In the U.S., as Ruth was mentioning, states with civil union laws include Vermont, Connecticut, New Jersey most recently, and again, somewhat surprisingly, New Hampshire. And by definition, of course, civil union law provides the tangible rights and benefits that go with marriage under state law. It does not provide the status of marriage. It doesn't provide any federal benefits. States that have domestic partnership laws that provide at least some of those tangible rights and benefits include California, D.C., where we are now, Hawaii, Maine, Oregon, Washington. So about a fifth of the states now have some form of legal recognition for same-sex couples. In the courts, we've only had two state Supreme Courts have ruled in favor of marriage. That was Hawaii back in '93, which was subsequently mooted by a state ballot initiative there. Massachusetts, of course. We've had two courts, state Supreme Courts, rule that states must provide either marriage or civil unions. Vermont in 2000, New Jersey very recently in 2006. We had two very disappointing decisions from the highest state courts in New York and Washington last year saying the state has no obligation to provide either marriage or any of the rights and protections of marriage. Rather shocking, actually, from two such generally progressive states. And then we are awaiting decisions in Connecticut, Maryland, and California. I just want to take 1 minute to acknowledge Dennis Herrera is here from the San Francisco City Attorney Office and his colleague Sherry Kaiser, who are litigating the California marriage case with us. And it's the only state where we have an entire municipality who is actually litigating with us, and we're incredibly grateful for your leadership on that, Dennis. Yeah. But our purpose here today is to talk about the differences between civil union and marriage and discuss which is the better option. And I think it's really important to be candid about the fact that there are few, if any, people who really like civil unions on either side of this question. On the one hand, we've got people who oppose both marriage and civil unions, like my colleague here, Mr. Ventrella. We'll hear from him in a minute, because they believe that being lesbian and gay is morally wrong. They think the state should not afford any kind of affirmative legal recognition to same-sex relationships because that encourages behavior that these folks want to discourage. Then on the other hand, there's people who think that lesbian gay people are worthy of the same equality and respect as others, and who believe that they should be able to marry. Civil unions are a political compromise. They were designed to provide some legal protection for lesbian gay couples, but without offending the sensibilities of the majority, who don't want to discriminate but who can't quite yet bring themselves to treat same-sex unions with the same kind of seriousness and dignity and respect as heterosexual unions. Then we need to remember that civil unions were not developed because same-sex couples and their children have objectively different needs or attributes than other families. They were developed in order to minimize any suggestion that the state is endorsing or supporting gay relationships, and to avoid treating those relationships with the same dignity and respect as heterosexual marriages. I think that's why it's doubtful in the long run that civil unions will be permanent institutions. They're the quintessential political compromise, and as the New York Times in an editorial just from June this year noted, a law that allows civil unions but not marriage is preferable to denying benefits and recognition to same-sex couples, but no one should confuse it with equality. And in practice, civil unions pose enormous practical difficulties and problems, which hopefully we'll be able to unearth here and discuss a little bit. But I just will end on that note with a plea that we don't fool ourselves about where civil unions came from and what are really the stakes of the issue, underscoring what my colleague here, Mr. David, said.
Thank you. I'm reminded of the old Monty Python line, and now for something completely different. Jeffrey Ventrella is Senior Vice President of the Alliance Defense Fund, which is very much on the other side of the issue. Jeffrey pointed out that it was a little bit inappropriate for him to be seated on the far left here, but he's on your far right, and it's very good of him to come and share his different perspective. Jeffrey.
Thank you very much, Ruth. And I, too, want to express my thanks to the American Constitutional Society, as well as the sponsor, Sidley Austin, for, if nothing else, rescuing me from the Ninth Circuit, if only for a day. See, that gets a big joke at Federalist Society events. Doesn't get one here. I see Dennis, a friend of mine, colleague. I am very grateful for this opportunity because this is a very important issue. It's important legally, judicially. It's also important as a policy matter. And there needs to be reasoned debate, dispassionate and yet passionate conviction about these kinds of things. This particular issue, though, steps on all the taboos of polite conversation. Because to talk about civil unions, to talk about same-sex marriage, you have to talk about sex, politics, and religion. And if you're bored with those things, you probably don't have a pulse. But the fact is, it gets a little uncomfortable talking about these things, and I think that we need to kind of clear the air a bit and understand what we're doing here. I think you'll find that on this panel, to a person, we all agree about a number of things. We agree about the goals. We ought to have a policy and institutions reflecting the policy that does affirm the personhood and dignity of each and every human. I think we all agree on that. I think where we disagree is on the means to obtain those kinds of lofty goals. The distinction of that position that I'm going to be articulating is one that everyone here has said civil unions are a bad idea. And I agree with that. I also, though, agree that marriage is a unique entity, that we ought not to have a smorgasbord of cohabitational opportunities, or rather, we ought to have marriage. I think it's unique, and for that reason, it ought to be specialized, not made the same as everything else. I think that marriage is optimal. It is the optimal environment for purposes of the next generation. I also think that marriage has a structure that needs to be recognized and not get ahead of the horse, so to speak. That marriage, and the courts have held this for years, including the United States Supreme Court has reaffirmed it for years, that marriage has a structure. It has a quantitative structure. Only two persons can be involved in marriage. So polygamy, polyamory is out. And second of all, it has what I call a qualitative structure. That is to say, recognizing the complementarity of design between men and women, male and female, that is designed for one man and one woman. And that is why it's been affirmed over and over again. Now, having said that, that can be a little prickly, and so I want to emphasize what's not at issue in this particular discussion. The first thing that's not at issue is animus. Oftentimes, there's a lot of epithets that are thrown around, sadly, on both sides of the debate. But animus is really not the issue. Let me show you what I mean by that. If I am for affirmative action, that doesn't mean I have a hatred for white people. I mean, obviously, it doesn't follow. Well, in the same way, if I am for marriage between one man and one woman, it doesn't mean I have animus or hatred for same-sex couples. That just doesn't follow. And so we need to really take off the table the notion of, well, you're just, a homophobic bigot or something like that. That's just not the case. I think the other thing that's not at issue here, and I'm going to disagree with Mr. David at this point, is sexual orientation. Sexual orientation, as it relates to the marriage laws, is not at issue. Think about it. No marriage amendment, no DOMA, federal or state, federal signed by William Jefferson Clinton, by the way, no marriage license inquires as to sexual orientation. It's just not an issue. There's not anything that says homosexuals can't marry. It doesn't do that by way of law. It's really a non-issue. Now, it may impact different behaviors and so forth, but it's not a legal issue. Okay? And please understand that. I think the other thing that we have to understand is that the marriage laws are not about marrying the person you love. Now, don't get me wrong. Personal affection is very important interpersonally as to partnering and so forth. And it exists, okay? But it's not legally relevant. Again, think of it this way. Does the marriage license measure the quantity of subjective affection between putative spouses? No. Would we want the state to say, you know what, you can't marry this person because you don't love this person sufficiently, both in terms of quantity or in terms of quality? No, that's not the state's job to do that. So we need to take those issues off the table. What is the issue as it relates to this question of marriage? The issue is simply this. The issue is what's at stake is the structure of marriage and what the state does with respect to that structure. Now, the state does two things. It recognizes marriage, and then it regulates within marriage. Okay? The United States Supreme Court has said this years ago. The state does not create marriage. Rather, the state recognizes marriage. And then within that recognition of that structure, one man and one woman, two people, what it does is regulate within that. And so, as Mr. David says, there's been changes with respect to the legalities of certain aspects of marriage. In each and every case, and you'll find this not only in American constitutional law, but you'll find it in Western civilization, in each and every case, those changes have been regulatory. They haven't dealt with the structural component of marriage. The fundamental right to marry, as expressed under American constitutional law, is the right to enter that structure. When we had deplorable laws like the miscegenation laws of Virginia, just across the border here, that was not a proper application of the structure. It was a constrictive application of the structure, something the common law abhorred. And unfortunately, the racist policies of a number of states had these miscegenation laws, which did not bar African Americans, for example, from interracial marriage, by the way, if you read the law. What it barred was white people. How disgusting is that, from interracially marriage? Except for white people could marry Indians because they had a Pocahontas exception, and I'm not making this up. This is just horrible, misguided marriage policy at the legislative level of Virginia. Well, the Supreme Court correctly corrected that. Now, shortly after that correction, same-sex couples brought lawsuits to say, well, we're just like the situation, and that was tried, it was tested, and it was rejected. And even today, and that was at the Supreme Court, by the way, not one federal court has found that sexual orientation is a suspect class. And for good reason. There's some real problems with that analytically. And so we need to understand what the role of the state is with respect to this. I think everyone seems to agree here, too, that the judiciary is not really the mechanism for addressing this issue. It should be a policy issue within the legislatures. We do have legal guidance with respect to that. And I think that as we talk about these issues, some of these things will more and more come out. I'm just going to concur with respect that I think civil unions are a wrong-headed, ill-advised policy for a host of reasons, not the least of which is it's simply not the same. Those who simply cohabit are not the same as those who are marriage, because the foundational assumption is one of companionship rather than commitment. And I think that the marriage laws recognize commitment as opposed to merely companionship. And then finally, marriage is not about access to benefits. There are many, if it were to be about access to benefits, and that's all it's about, it would be grossly under-inclusive, because you're discriminating against a whole host of relationships that have true dependency, that have true need for support and benefits and access and that sort of thing. And just limiting it to two people is wrong-headed. Limiting it to those who are simply sexually intimate is also wrong-headed. And so this whole idea that it's this benefit-driven analysis, I think, is mistaken. It's under-inclusive. It's exclusive. And by the way, it's not necessary. As Shannon indicated, in what happened in Hawaii, they passed a reciprocal benefits provision to their constitution saying, look, if you can demonstrate dependency and so on and so forth, you're entitled to those benefits. They did that by protecting the structure of marriage and yet addressing the needs with respect to those who are cohabiting. So for all those reasons, we all agree and I disagree. Thank you.
Great, thank you. Jeffrey touched on two really fundamental questions that I think we want to address today. One is what the role of the courts is, because I'm not sure that everybody up here would agree with his assessment that the folks on the panel don't think that the courts have a proper role here. But I think the other thing that we ought to get to is kind of straight to the nitty-gritty of where civil unions fall short or why civil unions aren't, in the view of, I think, all of the panelists, the proper answer for same-sex couples. So since you were saying that that's a big piece of your public education right now, Carrie, maybe you can start to address that and others can chime in. And maybe Jeffrey can explain, given his view that there ought to be protection for people's dignity and autonomy, why civil unions, from his point of view, are perhaps not as abhorrent as marriage, but not also not appropriate.
Well, I think the biggest area that we've seen this discrepancy in the states that do have civil unions is in private employers being able to wiggle their way out of it and not treat couples the same, even when the legislature has intended in their legislative intent to say civil unions are equal. I mean, just this week, we've seen Governor Corzine in New Jersey get involved in the whole UPS situation in New Jersey, where UPS is refusing to honor a UPS employee's civil union partner as a spouse. And it's interesting that the governor has stepped up to reaffirm the legislative intent that the New Jersey legislature had. We've seen employers, especially small employers in a lot of these states, just really refuse to comply, and there's no real enforcement mechanism. Who are the police going to come out and issue, who is supposed to enforce this with state government being strapped and then not being clear what's violators, what is the punishment? I mean, there's nothing written into any of these civil unions law what happens when you don't treat a couple with all of the same privileges and responsibilities as a married couple. So that has been a tremendous headache that we've seen, real life consequences like health insurance, like pension, and there's a couple in New Jersey that the Star Ledger wrote about, that he, while the company let him add a civil union partner to his pension, they said, well, he's only going to get, though, 50% of your pension, even though if he was your legal spouse, he would get 100% of it. So, what's he supposed to do? I mean, the company is saying this is, what we're going to do. So we've seen that. And then I think, the big one that we've seen is what happens when these couples leave their home states. Everyone knows about the Vermont-Virginia fiasco and the heartache that family has had to go through on both sides. The woman who is trying to invalidate the civil union and the subsequent child custody and visitation order, and the child herself and the other partner who's being denied this, and the whole judicial crisis that went on for years deciding who had jurisdiction and what was a civil union in the Commonwealth of Virginia. And now that we have additional states added to that mix, we're going to continue to see this as people leave their states, even, visiting, other states and moving to other states, and, international recognition, I can't even imagine saying to someone, well, this is my civil union partner, people would be like, what the heck is that, if you're in Russia or Asia. So, I mean, we're just starting to see some of these real-life consequences for real people and real issues.
Let me pick up on that and ask if, just for the sake of argumentation, which is pretty much what they pay me to do, which is a great job, maybe it's just a combination of a few things. Maybe the problem with civil unions is just a drafting problem and a problem of society getting used to a new set of arrangements. Maybe if we, as everybody gets comfortable with this scenario, we'll have a clearer set of legal rules about pensions and things like that, and we'll figure out enforcement mechanisms, and social pressures will come to bear on companies like UPS, one. And similarly, I wonder if, in terms of the issue about what happens when you leave the state, either permanently or temporarily, if marriage is a solution to that, given DOMA, and given the litigation that's going to be inevitable over the implications of the full faith and credit clause there. So on both of those questions, why just sort of better drafting, better enforcement, clearer set of rules, and on interstate issues, maybe Alfonso, you can just pick up there, because you obviously sorted this through as New York decided to propose the marriage.
Right. I constantly go back to my original premise, which is we have created a separate institution called civil unions, and we always have to ask ourselves the question, why? When we already have an existing institution that would provide all of the same rights, privileges, and benefits to those same-sex couples. With respect to the interjurisdictional issues, which I think is indeed quite fascinating, because you have same-sex couples that may have legal rights, or in some cases do have legal rights in their home states, and if they travel to another state, say Florida, for instance, or another state where there is a Defense of Marriage Act, and they have children. I've had couples, as an attorney at Lambda before I joined the Spitzer administration, I had clients that would contact me concerned. We have a second parent adoption. We live in New York State. We had a marriage in Canada. We want to go on vacation in Florida. We're concerned about whether or not we will be considered legal parents to these kids when we go to Florida. Because under Florida law, we're not considered legally married, and we may actually have no legal rights to these kids. And those are real, tangible concerns that parents have to deal with, simply because we have state DOMAs and then we have the federal DOMA. I do want to respond to what Jeff said earlier with respect to the foundational assumption, because I think that underscores my original point. He mentioned that the foundational assumption of same-sex relationships is companionship and not commitment, and then concluded by saying, well, I think all individuals should have dignity, and that's what we should be striving for. Those are fundamentally inconsistent concepts. If we're going to say that same-sex couples and their relationships are about companionship and not commitment, and at the same time say that everyone should be entitled to dignity, how do you achieve that goal? And I don't think that civil unions achieves that goal for a number of reasons, including the interjurisdictional concerns.
Ruth, can I tag on to this question? Because I think you have really identified what a lot of people think. That, well, yeah, there's problems with civil unions, but they're going to sort themselves out in time. I mean, that is the heart of it. The reason they're not going to sort themselves out in time is because the whole concept of civil union is based on something that is just fundamentally irrational, that sends a mixed message, and it always will. Because as I was saying earlier, there is absolutely no functional or substantive reason to create a separate status for same-sex couples. There's nothing about those families where they have different needs or different qualities. The one and only reason to create a separate system is to maintain a privileged status for heterosexual people, because people aren't comfortable. They're just simply not comfortable saying, yes, same-sex relationships and their children and their families are equal to mine. We're getting there. I think public opinion is rapidly shifting, and more people are comfortable with that. But the civil union law, at every turn, if you think about all the places in your daily life where you identify your marital status, you're applying for a job, you're filling out paperwork, you're renting a car, is your spouse going to be driving the car? Every time you do that, if you're in a civil union, you have to announce that you're gay. It is the state, by force of law, labeling with a big neon sign all lesbian and gay people who live inside a particular jurisdiction and forcing them to constantly call attention to their sexual orientation. The state is telling the entire world sexual orientation is a relevant category. If the state, by law, is saying, we think there's some reason to treat gay people differently, what message does that send to everyone else? Of course it's going to encourage other people to discriminate. It encourages private discrimination and public discrimination. And that's why what we see in practice, people don't respect civil unions or domestic partnerships. That, it could get a little better over time as people get used to it, but it's never fundamentally going to change for that reason, because it's based on something at bottom that is all about and only about sending that message that these families are different and they're not quite as good as heterosexual couples and their children.
Jeffrey, what's the problem with civil unions from your point of view?
Well, let's see. This panel is dedicated to equality, so I hope I get equal time on the issue, not just on a person-by-person basis. A lot of problems with civil unions. First of all, if you support marriage, you can't possibly support civil unions, because civil unions, as well as any other form of cohabitation, dilutes the specialness, the uniqueness, and the optimumness of marriage. If we're going to use marriage, we have to not use it in an equivocal sense. What I mean by that is, if we're going to esteem marriage, then we have to also fill that concept with things like it's the exclusive place of cohabitation, it's the exclusive place for sexual expression, it's the exclusive place for the rearing of children, talking in terms of general normativity and so forth. What you'll find is, folks, and I've talked to people about this, I said, do you think that having a same-sex marriage is morally equivalent to the quintessential one-night stand, anonymous, intimate behavior? Oh, no, I couldn't say that. Or actually the opposite is yeah, that's exactly the case. One's not better than the other. And so until the messaging gets very clear here that marriage, and only marriage with respect to partnering, I think there's a real problem with that. I think civil unions thereby really denigrate the institution of marriage.
Jeffrey,
They help redefine it. I want to talk about the dignity issue, because I think that's a significant question, if I may.
Sure.
When we talk about dignity, we have to roll up our philosophical sleeves a bit and ask, are we talking dignity ontologically, that is to say humans as humans, or are we talking about dignity in terms of the liberty to pursue the common good? Those are two separate but related issues. And what I mean by that is simply this. If we're actually going to commit ourselves to the dignity ontologically of each human being, it would have far more credibility to say that then human beings in the embryonic stage are entitled to life, human beings in the fetal stage are entitled to life. Because if we're talking about dignity, then we can't have essentially developmental apartheid. The idea that, well, just because this person's in a womb makes them expendable, you see. And so we're sending, again, mixed messages. If we're going to be consistent on the dignity message, then we have to rethink this whole notion of abortion and so forth. Now, if we're talking about teleological dignity, then the question becomes, what are those structures and conditions that best promotes the common good and thereby the good of each and every person? Civil unions work against that. Why is that? Civil unions are a mechanism by expanding what I would call radical autonomy. I just get to choose whatever I want to do, whether it's civil union or whether it's shacking up or whether it's anything else. The trouble with that is you can never affirm the relationship and the societal bond that we call marriage, which is the future of our culture and society, by simply having that sort of thing. The relationship always suffers when you have those kinds of pretenders or counterfeits. And so we come to the same conclusion on this panel. I totally agree, too, legally. Let's get out of the philosophy for a moment. The Article 4, Full Faith and Credit Clause, doesn't apply to marriages. I hope you recognize that. It only applies to judicial pronouncements, things like divorce decrees, judicial decrees, and that sort of things. And so you've got this horrible situation going back and forth where you're just creating chaos and anarchy within the judicial system. You couple that with the fact that we're a federalist system. We have national policies as to retirement benefits, something called ERISA. God forbid that I would be involved in anything involving ERISA, but the fact of the matter is some people like that stuff. Well,
We rent
ERISA...
the panels next door.
Yeah, and that's a good thing. And so the idea that we're having, we can somehow have this crabbed hodgepodge idea without a uniform policy seems to me is not very beneficial policy in the long run. Couple that with international issues, some of the things that Carrie talked about, and then you've got even bigger issues. Because if you don't have the structure of marriage as one man, one woman, then if you're going to really talk about equality, then what about the faithful Islamicist who has 4 wives? Do we have to recognize the polygamous situation? Now, a number of local advocates are making that point. Beyond Marriage on the web makes that point. The ACLU makes that point. So, yeah, exactly. We have to have total marital autonomy.
I want to bring us back from abortion and polygamy to talk about the world as you see it, because you talk about how marriage is the quintessential institution for example, raising children. But the fact of the matter is that there are hundreds of thousands of children being raised by same-sex parents, by gay parents, and so don't we need some kind of legal order to help regulate how those families and how those parent-child relationships should exist? Don't we need some kind of legal order to help regulate things like access to hospital rooms and medical decisions and things like that? And isn't the sort of point of view you're taking, and again, I'm arguing here, just sort of wishing gay people away? And that doesn't seem to me at this point in our culture to be particularly practical.
Yeah, about 40% of those who obtained Vermont civil unions were previously married to opposite-sex spouses. So there was no barrier to marriage. It was just there was a different choice that occurred. That's simply a fact. Your point about that these situations exist, yeah, exactly so. But the is doesn't produce the ought. The is informs us, and we have to respond to that. We can't make a fallacy of going from the is, there are these situations, therefore we must somehow create this thing. I think the law already addresses a number of these issues, not each and every one of them, but the law does. For example, with respect to children and property and testamentary rights and that sort of thing, we have intestate succession statutes so that the biological parents certainly have a relationship there with the children. We also have, again, another class I didn't enjoy very well, trusts and estates, but the reality is those kinds of mechanisms exist, and a lot of heterosexual or same or opposite sex couples who marry have estate plans. It's not deemed to be an extra burden to do that. People do that. The patient controls a lot of those visitation kinds of issues in terms of the medical issues. So I think it's a bit of, the sky is falling to suggest that in each and every case there's absolutely nothing out there with respect to care and taking care of these families and these living arrangements and so forth. I disagree with, I realize you're arguing with, but the idea that, well, these certain people should just go away. I don't think so at all. But I do think that that's a different question from what's the structure of marriage. And structure of marriage, and again, the courts have been absolutely firm on this, unless they've, like Massachusetts did, decide we're going to redefine it. Okay.
I'm glad you said the word courts. I really want to make sure we leave enough time for questions, so I want to ask everybody to be pretty brief on a subject that doesn't lend itself to brevity. But I think it's very important to talk about whatever your view of the right result here. I'm not sure whether it's strategy or tactics, but to what extent is it preferable or necessary to have court involvement on these matters versus having legislative decisions, as New York is talking about? Some people, even very forceful advocates of full equal rights for same-sex marriage, also argue that it would be a mistake for courts to impose this on states or on the nation, much sort of analogous argument to the federalism argument against Roe. And so I think it's important for us to discuss that also. And Shannon, you got the sort of short moment before, so maybe you could address that.
Oh, sure, yeah. Well, I mean, of course, it's important for courts to rule on these issues, and the right to marry is an established fundamental right. It's one of the most cherished, important human rights in our society. It's exactly the kind of rights that courts are supposed to enforce. So there's no doubt about that. And we've seen in Massachusetts, after some people didn't like the Goodrich decision in 2004, but what we have seen happen there is just an absolute transformation of social culture, of the culture in Massachusetts, where people letting same-sex couples marry had a transformative effect, where people could see their lesbian and gay neighbors and colleagues as full human beings. And I think people there have been so struck by that. Didn't in any way undermine the legitimacy of that court. The decision now is overwhelmingly accepted by the vast majority of people in Massachusetts, and lesbian and gay people there have reported to the rest of us, and this has been true in Canada as well, that just the transformative effect is hard to describe. That you go from being an outsider, kind of an outlaw, to just being a regular accepted member of society, and that is ultimately what this is about. That is the ultimate question. And Mr. Ventrella says he doesn't want people to go away, but he doesn't want them to be gay. But most people, I think, I respect your right to have that opinion. I think there's a very small number of people now who are kind of in that camp with you. I think most people recognize that lesbian, gay people do exist, and that they will always exist, and that they have a right to exist, and that they're pretty much just like everyone else, and that our collective task is how do we integrate lesbian, gay people and their children into society. The best way to do that is to treat them the same way as everyone else. Let them marry. Don't create some separate institution. And of course, that's a job for the courts and for all the branches of of our government. We all have a duty to enforce constitutional rights. But more than that, more than anything, it's about just our responsibility as members of a society and a democracy to embrace and accept our neighbors and to help create equality. I mean, courts don't get that far out ahead of public opinion, but we all have a collective responsibility to do the right thing, to treat people with respect.
If public opinion is shifting, if there is this transformative effect, and we've seen it, and if there is a risk, and you can take issue with the premise, but if there is a risk of a backlash in terms of people being resentful of courts imposing their views on states, why not let this process perhaps play itself out over a longer period of time, and perhaps in a little bit of a patchwork way, but let states and society get there on their own rather than having courts impose it on them?
I would just, point out that, in the Deep South, we're still in some states not even polling at 50% acceptance of interracial marriages. So there's just some issues that I think we've talked about that are so fundamental to who we are as people in this nation and our Constitution that, we're having the same debate in Maryland about the referendum. We have some good-hearted legislators who are like, well, why don't we just put this to the people? Like, I don't, understand. They're going to be reasonable. They're going to be with you. And, it's straight people who are saying that. And, as gay folks, we know that, 99.7% of the time, if you put our lives and our families in front of our neighbors and stuff, we're going to lose, and that is going to be detrimental to who we are as a community and to our quest for equality in Maryland. And so it's been an interesting insertion of this whole democracy argument into our debate. I mean, last year we showed up for the constitutional amendment hearings in Annapolis, and I was with the ACLU person, and we saw these people with things that said, let us vote. And so Meredith turned to me and she's like, oh my God, there's a voting rights bill I should be testifying on. And she's freaking out, she's running around. But it was that their new slogan for the constitutional amendment in Maryland is, just let us vote. That's all we're asking for. And so, it is really, like, I am not willing as, somebody who is lesbian and achieving equality for my community to put the rights of my community before people. I mean, it's just, it's not. If, you know, somehow, you know, with the numbers for acceptance of the civil rights of other groups had changed public opinion, then maybe I would have a different thing, but I don't have confidence that if the courts don't intervene, that the country will step up to it. So.
Can I ask, I want to ask Alfonso about state versus federal courts and state constitutions versus the federal constitution. Ultimately, from your point of view, is this an issue that's going to need to be decided on a national constitutional basis rather than as a state court by state court matter?
And you're asking my personal opinion?
Yes.
To be clear.
To be clear.
Yes, I do think that this issue has to be decided by the federal courts ultimately. But I think that if we take a look at history, we'll find that in other civil rights movements, including interracial couples seeking the right to marry, the Supreme Court took 20 years to address that issue after Perez. And there's a reason why. The NAACP and other advocates that were working on that issue recognized that the Supreme Court has been traditionally conservative. And unless the Supreme Court recognizes that there is a conflict through the circuits, it's unlikely to rule in favor of the minority in most cases. When we had the Loving versus Virginia case, and of course there are exceptions to that principle, but when the Loving versus Virginia case ascended to the U.S. Supreme Court, the majority of states in this country did not have interracial or anti-miscegenation laws at that time. You could certainly make the argument that if the case would have proceeded to the U.S. Supreme Court prior to that time, Loving would have lost. And I think if you take a look at history, you will find that there were a number of other cases where they filed petitions for cert to the U.S. Supreme Court on that very issue, and they were denied. And I'm not going to read into why the court denied cert in those cases, but I think it's illustrative when we think about this issue. And does it really behoove us, when I say us, I mean in my individual capacity as a citizen, to move forward and seek review of this issue from the U.S. Supreme Court? You know, when you take a look at family law principles and marriage is a state institution. It's not a federal institution, which is why I think many people would argue that there are fundamental problems with the Defense of Marriage Act. This is the very first time that the federal government has infused itself into a state law issue. And I think that ultimately you will have federal courts grappling with this, you know, principle of federal courts stepping in and trying to define an institution that has historically been a statewide one.
Great. What I'd like to do now is open it up to questions. So I think we've got a microphone, and if we can just give it to, I'm going to let you choose. And it might be helpful to identify yourself.
Sure. My name is Brett Reynolds. I'm a law student at the University of Chicago. This question is primarily for Jeffrey, although maybe some others will chime in. So let me say as a way of setup that I think all of your oppositions to civil unions have not been to civil unions as a concept, but as practiced currently, which is an exclusive alternative to marriage. But given that, Jeffrey, you said that is should not imply ought, but I wonder if ought should not imply is on a different concept, because you said that marriage is about companionship. Excuse me. You said that marriage is about commitment and not companionship. But I think it should be about commitment, but is not, given the number of adulterous, abusive marriages that are out there. So I wonder what your objection would be to the libertarian solution, which is no state involvement in marriage. States can grant domestic partnerships and civil unions to gay or straight couples that want them, and then leave marriage up to private institutions, religions, otherwise, so that couples would commit to that beyond the state baseline that is about the benefits. So I wonder if you could respond to that objection.
Indeed. The libertarian argument is nothing new. It was tried during actually the 18th century, and it produced disastrous results. And it took Lord Hardwicke in his Act of 1753 to reaffirm order in society. What you had was that lost the presumption of paternity. You dealt with the scandalous abuses because there was no way for the state to regulate and have concurrent jurisdiction with respect to things that were going on. It was a complete disaster. I encourage you to read about that, and you'll see what it does. It leads to utter chaos. I think, and I've written about this and argued it, it is a shameful thing, and marriage is in trouble in the United States, and it's not those who practice same-sex behavior at all. It's the run-of-the-mill, like you said, adulterers, the faithless. I think 75% of heterosexual men are faithful. That's it, 75%. I mean, it's deplorable. Now, one of the institutional reasons for that is the lack of, I think, church discipline on those issues, and that's one of the barrier organizations. But also, and it's sad to say it, but it's a horrible experiment. And though there were some issues with respect to spousal abuse, I understand that. But no-fault divorce. No-fault divorce was a terrible experiment. And I think that people in this room, I see a lot of students in this room, you know, I just want to be with the person I love. Well, you probably heard that the first time when Dad walked out on Mom. That's the statistics that we live in today. That's the demographics. I just want to be with the person I love, so I'm going to jettison the family that I have. And no-fault divorce was a horrible, willing accomplice with respect to that. So I agree with you. The issue of civil unions, the issue of same-sex marriage, sits on the foundation of erosion that was tilled the soil, so to speak, with respect to no-fault divorce. The libertarian answer is simply not an answer with respect to that. Again, historical precedent would be Lord Hardwicke's Act, 1753.
Anybody else want to address the question of why we just can't grant everybody every couple that's seeking it, that would like it, some kind of civil license? We can call it a potato license, not a marriage license, and leave marriage to religious and other institutions?
I would just say what I said before. When there's a serious proposal, when libertarians or whoever's behind that, as a community, as the LGBT community, we don't have like time or energy or resources to be pursuing that right now, is the abolishment of civil marriage. And so, you know, we don't. I mean, and so we're trying to get access to what is now, and I really don't think there would be, you know, opposition from our community en masse if that was like a serious proposal before state legislatures, you know, for, you know, the solution to this. But, you know, libertarians are going to have to take this on themselves, and, you know, we'll be good coalition partners.
Most people value marriage very deeply, and that most lesbian gay people also value marriage very deeply and would be very upset if the state abolished marriage. Marriage is a fundamental right. I'm not sure the state even could abolish marriage. But also, it's never been clear to me what is the proposed alternative. If the suggestion is that every couple would have to create their own contract and come up with all their own set of obligations and agreements, that would be incredibly burdensome for most people. Most people want the ability to join their life to another person and to have a prepackaged set of rights and benefits and the status of marriage that goes along with it. Marriage has been around for a long time, so it has a lot of social, traditional meaning and value that's valuable, just as valuable to lesbian and gay people, and they would like to participate equally. You know, we're not trying to get rid of marriage, we would like to participate in it.
And I'll
Great.
just...
Can I
just want to
okay.
say one thing. I think it is really, really important that we don't think about deconstruction without inclusion. Because when you're talking about deconstruction, you always have to think about who are the parties that are making those decisions. Currently, same-sex couples don't have a seat at the table. And if you're deconstructing marriage and you're arguing that it's going to be in their favor, you need to make sure that interested parties will make sure that they're treated equally. So be careful when we're thinking about deconstruction without inclusion.
Right, next question. Perhaps the gentleman right there.
Thank you. My name is Anthony Klein. I'm a Court of Appeal judge in California, and I am well, at least those people know, I'm the dissenting vote in the case that is now going to the California Supreme Court. So that's where I stand. Now, my question, which may surprise you, is really, I suppose, to Ms. Evans and Mr. Minter, who I would think are a little uncomfortable at the support they're getting from Mr. Ventrella on their opposition to civil unions. But you're also getting opposition from a person who must have much more credibility in your eyes, namely Bill Eskridge, Yale Law School professor Bill Eskridge, who has been for at least the last decade the most articulate, impassioned, and effective advocate for gay rights generally and same-sex marriage in particular. Now, as I'm sure you know, to the astonishment of many, his latest book this year basically takes the position, or argues, it's a political argument. He's now not writing law, now he's writing sociology. His argument is that the reason there is same-sex marriage in Spain, the Netherlands, all these other improbable countries, is because they had civil unions for so long. So now, this great advocate of same-sex rights is taking the strategic position. I mean, there's nobody who knows better the fundamentality of the right to marriage and the right to participate in that right of gay couples than Bill Eskridge. But Bill Eskridge is now arguing that the courts, you will not win in the courts. You may have won in Massachusetts, but you're not going to win in the courts. You haven't won, and I come from the state whose Supreme Court wrote Paris versus Sharp in 1948, 19 years before Loving versus Virginia. I come from a state in which the state legislature authorized same-sex marriage. The governor vetoed the bill, but the state legislature did it. And Eskridge, coming to terms with this reality, is saying, go for civil unions because that's the only way it is going to happen, like it or not. And I'll close my question by pointing out that the key vote on my court, which I obviously didn't get, based her whole theory on Eskridge.
Well, this is a dilemma. I mean, you know, as working for the state group whose, you know, mission is to make lives better for GLBT Marylanders, this is like Equality Maryland and all of the other state groups, Equality California, all of them, we are in, you know, and it's not a quandary to, you know, to say our goal is marriage equality and explain to Marylanders, you know, why marriage is what we are achieving. Does that mean if civil unions are put before us as, you know, we know realistically we don't have the votes for a marriage bill in Maryland. In 2008, if we have an outright loss, but the legislature comes to us and, you know, our friends say, look, we don't have the marriage bill, you're going to have to get involved in the 2010 elections, but in the meantime, let's pass a civil unions bill, you better believe Equality Maryland will be behind that bill because our job is to make the lives of GLBT Marylanders better. And while it's not, you know, perfect equality, we'll take those, you know, 459 state level protections for our families in Maryland. You know, we'll be like New Jersey, we'll be like Steve Goldstein up there, you know, where he will not, the head of Garden State Equality, and he will not shut up, which is great about, you know, you're not getting away with giving us we have civil unions, thank you, but, you know, he is there every day, you know, fighting for marriage in, you know, the legislature. And, you know, I can assure you Equality Maryland will be the same way. We'll be thankful for that step toward equality, but it will not be the end fight.
And with, you know, with all due respect to Professor Eskridge, he likes to be something of a gadfly on certain issues. There's a certain amount of pressure in academia to take oppositional positions. He has done that, I think, to the great detriment of our community, and I could not disagree with his position more strongly, and it's very painful that it has had the negative effect that it has had. He is wrong if he means that we should not be seeking marriage equality. If he's making a much more modest point, then it would be a different matter. And this may be the point that he's making. I have not read his most recent book. If he's making the point that we do conceptually have to get people to the point of thinking that lesbian and gay people exist as a legitimate minority group and that they should be given equal rights and benefits, that is certainly true. And people don't jump to that point without incremental steps. So I think you have to have different strategies in different states. In California, we have laid a tremendous foundation. We have had a domestic partnership law that has been incrementally increased over time, and I hope and believe that we're now at the point as a state where people are ready to take the step to full equality. And I think there's going to be many other states where it will be absolutely necessary to have interim protections like civil union and domestic partnership laws. What we can't lose sight of, though, as a movement is that if we stop asking for full equality, we will never get it. We cannot throw marriage equality out the window as our goal and say, no, we really, all we want is a separate status that's not ever going to give us full social, political equality. So I'll read his book and see what he's talking about, but if that's what he's suggesting, I think that would be very unfortunate.
Great. Those have been two terrific questions. Let's try to get some more. There's a woman over here in the black jacket who's had her hand up.
Good morning. My name is Sonia Elder. I'm a student at Duke University. I feel that often the B is thrown into our acronym as part of our community, yet we don't talk very much about bisexual people, and I wonder how civil unions or marriage equality in any way impacts bisexual people, and how you think that supporting this is going to help that segment of your community as well.
Anybody?
Well, I mean, I think the point's a very good point, because if the guiding principle is equality without parameters, and if you're going to, it's arbitrary, it's exclusive then to say that marriage should only be two people. And I don't say this in a flippant way, but you'll get the point, since I want to conserve time. Bisexuals are people too. Well, if that's true, and the idea is my marital fulfillment, then I deserve to be married to both a man and a woman as a threesome, because otherwise you're depriving me of a fundamental right based upon my self-identity. And so there's a real problem, a real philosophical tension there with respect to those kinds of issues. So I think there is that component as well, and I think you've identified it correctly.
I'm going to speak personally to this issue, because I think that we're conflating two separate concepts, personally. When we're talking about the fundamental right to marry, that fundamental right is held by the individual, not by the couple. So if Mary or Peter is denied the right to marry because of their sexual orientation, it is because they are being denied the fundamental right that they own. Now, someone who considers themselves bisexual, if same-sex couples have the right to marry, would be able to exercise their bisexuality as it relates to marriage rights, regardless of whether or not they were one sex or the other. I mean, I think it's a false premise to assume, and he's conflating two principles, that by allowing bisexuals to marry, that they're interested in marrying two people at the same time. Bisexuality is not defined as seeking the right to engage in a relationship with two people at the same time. That's not what bisexuality is.
Great. This woman right up here in the front.
Yeah, I think the point would be, who are you to judge? I mean, that's the point, because some person who identifies as bisexual may say, well, that's not me. That's the point.
I'm Sherry Soklin-Kaiser. I'm a deputy city attorney in San Francisco. And I was particularly interested in some of your comments, Mr. Ventrella, because I thought I heard you say twice that you believed that love should be separate from marriage, that marriage was not about personal affection, that the dad who was leaving because he wanted to be with the person he loved, that, he was morally wrong. And I guess I find that an interesting position to juxtapose against the view that same-sex marriage destabilizes the institution of marriage. It seems to me that by taking love out of the marriage equation and leaving it this sort of pure lifetime commitment between, I believe you said, two people of complementary design, not two people who want benefits, not two people who are in love, and asking them, to engage in this loyal relationship over time, I'm guessing you're not going to have too many people signing up in this day and age for the institution of marriage. It used to be different when women were financially dependent on men and the family was an economic unit more than anything else. But don't you think times have changed?
Well, certainly times have changed, but marriage really hasn't in terms of its structure. What I said was that personal subjective affection is legally irrelevant in the sense that the state doesn't inquire into whether or not there's affection between the putative spouses. And then the question, and I think supported by a lot of our libertarian friends, would be, and they shouldn't. They shouldn't do that. You wouldn't want the state. We hear all the time, we don't want the state looking into our bedrooms. Well, we don't want them looking into our hearts either. Okay? That was my point. Now, I'm not here to say, if you're taking it outside the legal context and talking about the society that's created when a man and woman come together, well, in that sense, then of course personal affection. I mean, my wife and I have 9 children. I mean, if you don't love one another, you're going to be whacked. I mean, it's just that simple. So it's certainly an issue. So please don't hear what I'm not saying with respect to that. But I think what we've got to do is grapple with this other question then. Why don't we license friendships? There's a lot of friendships, for example, that have deep affection and abiding durability throughout time. But we don't call that marriage. There's intimacy in certain friendships of a non-sexual variety. We don't call that marriage. What is it about marriage that the state, that is legally, ought to recognize and regulate? And the answer is that by intention or by consequence, when a man and woman get together, children are produced. And consequently, the state has, and many states have articulated this, an interest in responsible procreativity. Not that marriage is a license to procreate. I'm not saying that. That's a fallacious argument. But to say that that's what happens inevitably. Same-sex couples, in and of themselves, are 100% sterile. Bill Eskridge wrote about that in 1996. He and I were actually the featured speakers at a debate at Texas Bar. We agree on many things. We disagree on the end of things, of course. But there's a sterility issue, okay? And consequently, so there's a dissimilarity between the coupling that goes on. Whereas in a man and a woman who get together, irrespective of sexual orientation, the inevitability is that over time, over demographics, you're going to have children. The state needs to be able to have that institution to channel responsible procreativity. Marriage is the institution that's against deadbeat dads.
Okay, I think we can probably squeeze in one more question. The gentleman in the blue shirt with the tie back there. Oh, okay. Well, fight it out, guys.
I want to go back to the judge's strategic question because I live in Tennessee, which is not the deep South, but maybe the shallow South. Still, marriage is probably just politically off the table. So I'm wondering if it's not strategically still valuable to be advocating for civil union, which I forget who said it was sort of the ultimate political compromise.
Oh, absolutely. I mean, in these states, and, our 20-plus states with constitutional amendments, and, most of those would probably bar civil unions if tested. I don't think anybody, we have pending civil unions bills in several states and domestic partnership bills in several states, is, each state knows what it is a reality legally and politically, and will have the support of, if Tennessee Equality Project, says that's it, we're going to introduce, they couldn't do a civil unions bill because the constitutional amendment does prohibit that, but we're going to introduce a limited version of domestic partnerships. I don't think anybody would criticize that as what is right for families in Tennessee, both legally and politically at that time. So, I mean, in Maryland, we have a golden opportunity to, really achieve equality at, the marriage level, and that's what we're pursuing. New York has that opportunity as well, and so I think each state makes its own plan for
Great.
that.
Let's try to get equality of guys in blue shirts with ties and squeeze in one more question.
Thank you. My question is for Mr. Ventrella.
I'm shocked.
And so I know that you, along with...
Could you identify yourself?
My name is Benjamin Plenner. I'm a student at Yale Law School. I actually just took Bill Eskridge's class in sexuality, gender, and the law. So I know that you oppose civil unions, as does everyone else on the panel. I want you, for the purpose of the question, to just accept it as a predicate that we're in Vermont and there are civil unions. And I want you to consider a guy like me who's straight but does not want to enter an institution that I believe is discriminatory to like my friends and to gay and lesbian people in my community. And I don't want to get a marriage until my gay and lesbian friends can get a marriage too, and I want to get a civil union. And like, I was wondering what you think about whether I should be permitted as a straight man to get a civil union in order to express my First Amendment right to associate with my gay and lesbian friends and to refuse to enter an institution that I consider to be constitutionally impermissible and discriminatory.
Appreciate the thrust of the question, but it's kind of one of those questions that, can God create a rock too heavy he can lift, I'm not going to buy the premises, but for purposes of just hypothetically, I think, again, that we devalue the institution of marriage by any status that pretends to be equivalent to it. And if you want to support marriage, then you will not support civil unions, and you would not enter it thereby. That's the implication of it.
Great. Do
they discriminate against, for example, they discriminate in a number of ways. Can, for example, in Massachusetts, two brothers get married? I think they can under the law. Is that marriage? Is that what we mean by marriage? No. Well, in the same way, if civil unions say that what you use, straight people can't enter into it, does that discriminate? Yeah, probably. But again, the premise is so messed up, we shouldn't even cogitate on such things.
All right, great. I want to say I think it's been a terrific panel with lots of wonderful points and lots of wonderful and provocative questions, and thanks to all of you for coming. Thank you. And thanks to ACS and Sidley and Austin for having us.